Good morning, everyone, and welcome to the Children's Commission meeting. We've got several new faces today, so we're going to start with some introductions. First of all, I will introduce our new youth representatives this morning, and they've agreed that I will share their bios, and I'm very pleased to be able to brag on them because they're amazing young women. So first, in the lovely red suit over here, we have Emma Blackwell. Emma is a lived experience expert and youth advocate, now serving as a youth representative on the Indiana Commission on Improving the Status of Children. Welcome, Emma. She's a behavior specialist at Arsenal Tech High School, which I had the opportunity to visit on a traveling oral argument, and it is amazing, Emma, where she also graduated. In that role, she was committed to creating a positive and supportive environment for students within the community that shaped her own educational journey. Outside of school, Emma volunteers with Young Life, an after-school organization where she builds meaningful connections with youth and offers herself as a source of support. She's pursuing a bachelor's degree in social work at Ivy Tech Community College. She previously served as a youth advocate intern with Foster Success, an opportunity that empowered her to share her experiences, amplify the voices of other youth, and connect with platforms such as this commission. To Emma, public service represents the active pursuit of change in the world. Public service represents the active pursuit of change in the world. That gives me goosebumps just saying it out loud. It's about consistently showing up, advocating for what you believe in, and refusing to accept the status quo when you know better is possible. Wow, Emma. So please welcome Emma this morning. Anything you'd like to add, Emma? You're welcome. And right next to Emma, we have Jada Cuttress. Jada is also a lived experience expert, advocate, and recently appointed youth representative to this commission. She's currently working as a peer navigator for Firefly Children and Family Alliance and is actively pursuing her master's degree in social work. Jada graduated in 2021 with a bachelor's in social work, a minor in civic leadership, and a certificate in child neglect and abuse. She previously worked with the Department of Child Services for 3 years and continues to do consulting work with various agencies. She also serves as a graduate assistant with the scholars programs at IUI. In addition, she works with the Federal National Youth in Transition database, runs a parenting group for foster alumni who are caregivers or parents, does contract work with Foster Success, and supports the implementation of the parenting attachment curriculum at Firefly. She was recently nominated for the Jim Casey Fellowship. Jada is passionate about improving the child welfare system. She wants to help stop generational curses within the system and believes that those who have lived through it are the best equipped to lead the work. To Jada, public service means giving of yourself for the greater good, putting the needs of others and communities before yourself. I had an opportunity to meet Jada in listening sessions. So the judicial branch held a grouping of listening sessions with biological parents, foster parents, and youth, and took the information that we learned from those lived experts to the judicial conference and shared that information for positive change. So I know her to be a very bright young lady, great input, and I will share with Director Krupp her plan for the future is to become the director of DCS. So she's coming for your job, Director Krupp.
We've spent time together. We know each other. I'll groom her for that role.
Excellent, excellent. So Jada, anything you would like to add?
I would also add, let's help empower our young people and turn their trauma into triumph.
Please welcome Jada Cuttress. And I will now go around the room. We have another couple of new folks. I see Ms. Arbogast here from the governor's office. Do we have Mr. Ranney? All right, so let's start with Mark. Go around the room, introduce ourselves, name, role, anything else you'd like to add, Mark?
Herschel, Executive Director of the Children's Commission.
I'm Audrey Arbogast. I'm the Chief of Staff to Secretary Satch Dove, who is the Secretary of Health and Family Services. It's tough to follow two introductions like that, but
Mhm.
I'm very, very happy to have been asked to be a part of this and I be here. Thank you.
Eric Miller, Deputy Secretary and Chief of Staff for Secretary Rowe at FSSA.
I guess I'm next. Sarah Sailors. I'm the Director for the Division of Mental Health and Addiction.
Dale Devon, State House Representative, District 5, but it sounds like with these new folks that with their goals and ambition, we may not need DCS by the time she's ready to be director.
Good morning, Eden Beasy. I'm here in proxy of Dr. Weaver. I'm an assistant commissioner at the Health Department overseeing women, children, and families.
Thank you, Judge. Chris Naylor, Executive Director for the Indiana Prosecuting Attorneys Council.
Adam Krupp, DCS Director.
Denise Corley, Executive Director of the Indiana Public Defender Council. Brooke Pennington, I'm Chief Operating Officer for the Indiana Department of Education on behalf of Secretary.
Good morning, I'm Stacy Donato. I'm the Indiana State Senate District 18, which is North Central Indiana, very rural, and I've been on education since I've been in office.
Good morning, Alenia Moore. I'm filling in for Terry Decker with Department of Corrections. I'm the Director of External Relations for Division of Youth Services.
Good morning. I'm Vanessa Summers, State Representative for House District 99.
Great, welcome everyone. I'm Dana Kenworthy from the Court of Appeals and formerly trial judge from Grant County. Since we have some new folks, I will first remind everyone to talk into the microphones so that the folks watching online can hear everyone. There should be one for every two people to share. And I'm just going to walk through some of the roles and participation expectations. Look there, young ladies. Your pictures were there. All right, so as you may have heard before, this commission was established around 12, 13 years ago to create a bipartisan three-branch group to perform several roles and responsibilities, thinking that this is the best way to build policies that are evidence-based, informed by the various folks who work with youth across the state, and are well vetted by everyone involved with our youth. So this group was charged with studying and evaluating issues related to youth, including access, duplication, funding, barriers to services, and communication and cooperation by those agencies serving youth, implementation of programs or laws concerning vulnerable youth in our state, consolidating existing entities so we don't have duplicated services, focusing on data, evaluating outcomes, targeting efforts, and demonstrating outcomes. And I will say on this point, with the Youth Justice Oversight Committee, we are closer than we've ever been to having a statewide data system to track juvenile justice outcomes, which is amazing. Still a lot of work to do, but we are closer than we have ever been, thanks to this initiative. We also look at crimes of sexual violence and the intersection with technology, including new technologies that are coming. We talk about legislation and make recommendations concerning legislation. So we have a legislative agenda each year that we discuss and agree upon. We promote information sharing, best practices, policies, and programs. Cooperate with other child-focused commissions, provide staff support to other child-serving committees, and submit reports to the Legislative Council, the Governor, and the Chief Justice. So truly a three-branch initiative here. And I will share with you that last week I had the opportunity to attend Council of State Governments program, a leadership development academy in Lexington, Kentucky. The attendee list was 40 legislators from across the United States, 7 executive branch officials, and me representing the judiciary. So it was very interesting to hear about initiatives in other states. And one thing that I was really struck by is the lack of 3-branch committees or commissions doing this sort of work. And so I came home from that incredibly grateful that Indiana has this unprecedented level of collaboration, communication, and support around an issue that we can all get on board for, right? We all want our children to have the very best chance of success going forward, every opportunity to succeed in Indiana. And so I just wanted to pass that along to you, that I was amazed at the number of people I asked about initiatives like this, and they said, no, I don't believe we do anything like that in our state, or I'm not aware of anything like that in our state. There was one other state that could answer that question in the affirmative, and that was a Kansas legislator who shared that they have something around children's issues. But it looked like a very specific topic. So look around the table and look at all of the folks here ready to do the work to improve the lives of children in Indiana. And that's just amazing. Expectations of Children's Commission members. All members are either named in statute by their position or they're assigned by an appointing authority as indicated in the statute. The voting for the commission is not by proxy, so there's no proxy voting here. So the affirmative vote of a majority of all voting members, not just those members present, is required for the CISC to take action. And that's why it's very important that we have the decision makers at the table for voting. And the legislators, the folks who drafted this legislation, deliberately said we need the decision makers at the table because this is an important issue. We're prioritizing this issue, and that's why we need the decision makers at the table. So I can't highlight enough how thankful I am to see folks here committed at these meetings. We generally have very good attendance, and so thank you all for being here, ready to do this work. Roll up your sleeves and get busy. All right, first action item on the agenda is minutes from April and June. Have you all had an opportunity to review those minutes? We have a motion and a second. Any discussion about either set of minutes? All in favor, say aye.
Aye.
Opposed, nay. All right. The next item on our agenda is Juvenile Justice and Cross-System Youth Task Force recommendation. You have a proposal in your packet, and we have with us today Nancy Weaver, familiar face, as well as the Honorable Holly Harvey, who are the task force co-chairs, who will be presenting the proposal to the commission. Welcome.
Good morning. Thank you, Judge Kenworthy, Mr. Fairchild, and members of the committee. Thank you for allowing us to be here today. My name is Holly Harvey. As you know, I am the current and new co-chair of the Juvenile Justice and Cross-System Youth Task Force. I also serve as juvenile court judge in Monroe County, and my docket consists of juvenile delinquency cases as well as juvenile chins and adoptions. With me today are Joel Winnicky, who is an attorney with Child Advocates, who will be presenting these slides today, and Janae Hanger, who's also an attorney in this juvenile justice space with Waples and Hanger. So as Judge Kenworthy was trying to explain for the new members, you know, the role of the commission, task force are also appointed and asked to work on the very important work of the commission. Our Juvenile Justice and Cross-System Youth Task Force has been, I believe, the longest standing task force of the commission. And it is comprised of a lot of different members, basically comprised of a cross section of multiple stakeholders in the state whose expertise really informs the work of our task force. Oops, sorry, wrong. Okay. The strategic goal of the Juvenile Justice and Cross-System Youth Task Force is to improve the safety and outcomes of youth who come into contact with the juvenile justice system. And to achieve that goal, we've broken it down into 4 objectives. Essentially, we work in subcommittees whose job is to each committee works on a particular objective. And today, we are here to request the Commission's support for legislation intended to ensure access for families to youth who are in secure detention. The proposed legislation is intended to advance 2 of those strategic objectives. Number 3, which is to identify and encourage adoption of effective and promising programs and practices to support healthy development of children with an incarcerated parent. And that typically is just referred to as the chair with the Children with Incarcerated Parents Subcommittee. And objective number 4, which is to identify and encourage adoption of effective and promising practices and policies that integrate the science of child and adolescent development into the justice system's response to children and youth. In short form, just the Child and Adolescent Development and in the Justice System Subcommittee. We have Janae Hanger here, who is the chair of the objective number 4 subcommittee, who has been working on this legislation for at least a year and has done a tremendous amount of work trying to get some background and some support for that. And also Mr. Wenicky, Joel here, as his role as chair of the Children with Incarcerated Parent Committee, has kind of taken it as a good project to mesh objectives 3 and 4. So both of them have worked very hard. I think the legislation as a judge is very important. As I was thinking about this, even being on this task force and hearing the support from them, thinking about how that informs my decision-making in residential placement, secure detention, I think it's really important. So I'm going to allow Joel to take it from here. And he is very knowledgeable on the subject. So here we go. Thank you.
Thank you, Judge. I appreciate the vote of confidence that I'm very knowledgeable on the subject. So I'm Joel Wenicky. I'm an attorney with Child Advocates. I provide direct representation to older foster youth in the DCS system. A few of you got to know me in my previous role with the Indiana Public Defender Council as a resource and research and legislative attorney. And Bernice gave me that opportunity, and it was a great opportunity for about 7 years. So Indiana had a juvenile justice improvement grant from OJJDP, the Office of Juvenile Justice and Delinquency Prevention of the federal government under the Department of Justice. I worked on that with Amy Kourosis, who's now the head of the Indiana State Public Defender Agency, and some other great attorneys, Jill Johnson and Rachel Walensky is now her name. And that was a great experience. I think we did some good things to improve the landscape for juvenile justice in the state of Indiana. I know it's a complicated topic because we're perpetually concerned about finding that right balance of making sure that youth understand that there are consequences for their actions and that there will be, that there's a need to behave in a way in which promotes good society, safety for others. But we also have to balance that with the need to be compassionate and understanding and in recognition of adolescent development and the need to turn these little folks into good, productive adults who contribute to society. It's a tough balance. But I'm here today to talk about something that may be status quo, but we don't want to accept what the current status quo is, to steal some language from one of our youth experts today. So family visits for detained youth. Nancy Weaver has worked diligently with others in the JDAI, and I know several of the stakeholders here over the last several years to really reduce and try to make sure that we're only detaining those youth that we need to detain. So a lot of progress has been made in that realm, and there's been a lot of legislative work to that reality in the last 5 years. We had a juvenile justice task force that resulted in a very comprehensive piece of legislation that developed the need for properly assessing youth. Diversionary programs were formalized in the statute. It created the Youth Justice Oversight Committee that Judge Kenworthy heads, as well as this. So there's been a lot going on. In the background, Senator Breaux, who was a part of this committee for several years, also worked a few years on a piece of legislation to ensure that children who are detained would have access to visitation with their families while they're in the process of detention. It really jives well with the theory of juvenile courts. So the theory that supports the juvenile court process is something called parens patriae, where the state is inserting itself in the place of the parent in order to correct something that has gone wrong with the family in order to rehabilitate the child. But the ultimate goal is to get the family and the child back to where they need to be so they can resume their, proper role as the parent, I guess, taking care of the behavioral concerns of the child and leading that child in their experience and growth to adulthood. There we go. So specifically with visitation, while people are in facilities, the first quote is with respect to some studies for prison population in general, not directed only at youth. But family visitation for persons in custody has been shown to reduce misconduct while in the facility. I think that's what that's referring to, and recidivism upon return, reentry back into the community. But more specifically with juveniles, there's research that suggests that family visitation is associated with higher GPA, fewer infractions, that's speaking of while in the facility, and with a decreased risk of depressive symptoms in youth who are in custody. And those are goals that I hope this committee, and I know this committee, is interested in promoting for youth who are detained. To that end, Indiana law provides little guidance on what level of family visitation should occur for youth who are detained. We can look at that first statute that's cited there. That's in the policy and purpose chapter for the juvenile code. That's what chapter 10 or article 10 is. And it's to recognize the importance of family and children in our society, including the rights of a parent. And it goes on to talk about their, connection with their child. And so we have to first start from that standpoint that, we have to honor that parent-child relationship. The juvenile code is written from a, parent to child priority. There's a lot of states that have started recognizing the corollary that children have a right to their family autonomy as well. That's equal to that parent right to their children. The next two quotes, these come from the administrative code directives from the Department of Correction to juvenile detention centers. And so reading those two passages, you can intuit that there should be a requirement for in-person contact visits with youth while they are detained. And so just recognizing that the facilities have to provide sufficient space for that as required by the administrative code, and that punitive interference is not to disrupt family contact as long as security is not compromised. So that's the one area where we can say, listen, we have to have a break in the family contact because it's actually being disruptive and causing security risks for the facility or for the child, and that's understandable. But another thing we need to keep in mind, so we have 92 counties in the state of Indiana, but we only have 17 secure detention facilities. As a result of that, so when I was a public defender in Putnam County working with youth, my youth would oftentimes be in YOC, or actually since then, Vigo County or Swervey or some other place. And it wasn't guaranteed that they would be in any of those spots. It would be the spot where the judge could find available bed space for my client during the pendency of the case. And travel became a huge issue for both families and me as the attorney to go visit them in person. And not only that, but not all of these facilities are ran by a juvenile court. And because there's not a lot of guidance in the law as to what visitation should be for children and families in these facilities, they've all developed their own way of doing things, which we understand. And I think the recommendation from the committee to this committee or the task force is not to take away that discretion completely. Facilities need to be able to make their own decisions by and large, but there needs to be some sort of minimum floor in place to ensure that families are having this opportunity to engage, repair, rehabilitate, and make the communications necessary to ensure that, well, children are safe while in these facilities and that the families are building, right? There we go. So family access in the facilities. So Kate Province of the Indiana State Public Defender Office has some interns who called facilities to try to figure out exactly what was going on around the state. I believe they made contact with 10 or 11 of the facilities, and then Jill Johnson from the Marion County Public Defender Office did some research online to see what other facilities had online standards that we could review and try to figure out what was going on. So one thing that we did realize is that family access is frequently tied to behavior. And I can understand that to a certain extent, that's an understandable response to behavior. But it shouldn't be something that completely cuts off a child from their parents and their family. And this, one thing that we saw when talking to the facilities is that there's frequently a level system to where a child can earn contact with their families. But recognizing that children are oftentimes in a facility for a short period of time, there's not really a lot of time to earn that contact for some youth. And the other reality is some of the youth who most desperately need the contact with families might be denied it because of a perception that, you know, behavior should take that opportunity away. And just to share an example of someone that Senator Breaux had contact me while she was working on the legislation previously that didn't pass. There was a family in northern Indiana, and I'm not going to say which facility, but the child was an 11-year-old child with intellectual disabilities that was punished, and the mother was deeply concerned that for over 30 days she was not allowed to have a phone call or any type of communication with her child. And so she was extremely frustrated with that. And if she were here today, I'm sure she would be asking desperately for you to pass a piece of legislation, or not pass, but encourage a piece of legislation like this. So So specifically with phone calls, and this goes to the disparity or the different way of doing things around the state. We saw from survey results that facilities would allow between one phone call per week up to 2 phone calls each day, which is far in excess of what the recommendation in this piece of legislation is. 2 to 3 phone calls per week between the child and the family. And so that is very consistent with what the legislation that we're proposing recommends, which would be for 2 10-minute phone calls each week. Call length was, again, very different facility to facility. Several of the facilities limited it to 5-minute phone calls, 3 allowed up to 15-minute phone calls, 1 up to 20, and 1 allowed up to 30 minutes per phone call. Most of the facilities were not charging for these phone calls. They were just viewing it as a part of the per diem cost for taking care of these children. However, that was not true. They were completely across the board. 2 facilities were actually charging families for phone calls. And I think the number that comes to mind from the one facility that I saw an actual number was approximately 25 cents per minute for a phone call, which is not a lot of money. But the other thing that we have to keep in mind, I think that I have seen that facilities charge a fee for putting money on books to be able to access these minutes, to be able to use to have this communication. And the other reality we need to recognize, a lot of these families in the juvenile justice system, they are in poverty or at poverty levels. And so even a 20 some odd cent per minute phone call could be something that is a barrier in communication between the parent and child. In-person visits, I was glad to see that almost all allowed for in-person visits. One still did not. And on their website, there was still a COVID protocol that was, you could see that said that, all visits were suspended due to COVID. And my understanding is that visitation hadn't been resumed since then. And let's be frank, that's a big part of the reason why I'm here right now is because of what happened during COVID and the break in communication between families during that time. So the duration of visits from the survey, most were between 25 and 30 minutes for each visit. One facility would allow up to a 1-hour visit. And it may have been more than one facility. Forgive me, I can't remember how many it was. Now, the opportunity for visits was the challenge that I saw from the surveys. So one facility only allowed visits on Sunday. And so if you have another obligation as a family on Sundays, that could be a great barrier. Another facility allowed visits on Saturday or Sunday. And then other facilities had very short windows on select days. And when I say that, it was like a 1 hour in the morning, 1 hour in the evening. And while I appreciate they're trying to spread out times, a 1-hour window may not be conducive for the family to be able to do that. And 7 of the facilities did provide an option for audio-visual visits, which in today's modern world of electronic communication, I would have hoped would have been a higher number. It's pretty easy to set up an opportunity for a web camera type visit to be able to hear and see your child while they're in a facility. I'm going through this pretty quick. If anybody has any questions, please feel free. Yes, Rep. Devon.
Thank you, and appreciate all your work on this. When you talk about the parental rights, a lot of these kids maybe don't have a parent. Would it be guardian also?
So, and this actually came from Senator Breaux. She wanted the court to be allowed to designate another adult to be the connection for that child while they're in a facility. So who that would be, it could be, broad. And it's not always necessarily parental rights. Sometimes, parents who have chosen not to have contact with the child, but courts have not been involved to actually sever parental rights yet.
Okay, so, and would you say these visits should be supervised or at least videoed in case there's some type of a something's given that shouldn't be type of thing?
Well, I think that there's a role for supervision, but I would hope that not everything in a parent-child, or if it's an approved adult by the court, not everything is closely monitored and critiqued. I mean, with jails, we know that phone calls are frequently recorded and monitored and turned over to prosecutors for prosecution. But there is, typically my understanding is a jail phone call could be made to anybody as long as the offender has money on their books and the ability to call out. We're just talking about communication between a child and a parent or an otherwise court-approved adult, or sometimes we're talking about a child who's in a facility who's wanting to have contact with their own very young child as well.
And I know the jail I volunteered at for quite a while, they had a 1 through 4 scale of level of behavioral acceptance, right? So they'd come in at a 1 and hope to get to a 4. So if they're behaving well, they get more perks while they're there, type of thing. And I don't know, do all jails do that, or do you know, or juvenile facilities?
Many did. And so that was a part of the level system that I brought up at the beginning. And I think that's wholly appropriate to add additional benefits as long as we have a floor of communication that's protected. So if you want to have, a phone call every single day with your parent, and we tie that to a behavioral incentive that if you get your points and do things that you're supposed to do, you're allowed to have a daily phone call, that could be a great way to incentivize behavior. But we still need to make sure that we're protecting that minimum level of communication between parent and child.
Thank you.
Joel, I have a comment, not a question, and some know I'm very opinionated, so I'm going to share my opinion for the record.
Yes.
6 out of 13 limiting to 5 minutes is utterly ridiculous and unfair. And 25 cents a minute, you said, is not a lot of money. I would disagree, and I would say 25 cents a minute is punitive. And I don't care what class of individual you are in financially, I find it to be outrageously priced, and shame on these facilities for all of the information you've just shared.
The good news is most are not charging. So let's start from there, because
but half of them are limiting it to 5 minutes.
Yes.
That's ridiculous.
A 5-minute phone call is not a very good check-in, especially if the child is out of your care and you're trying to talk to them about the realities of what it's going to take for them to return home, whether or not they've talked to their attorney, what the probation officer might be telling you, because you have to keep in mind the parents are part of the strategic court case as well. They're not just a parent in this role at this time. They're helping a child navigate a very complicated court issue. So I agree. Thank you.
A quick question.
Yes.
When you were speaking about facilities offering different time slots for visitation, are there different levels of resources or staffing that has to be associated with the different types of visitation that impact a facility's ability to offer, a wider range of times for, family or guardians to come visit?
So I'm not going to say that there will be a staffing component to, bringing a parent into a facility, getting them to the room, getting the child from wherever they are in the facility, bringing them to the room, being at least within the area to make sure that there is a base level of supervision. There is a staffing component, but we feel that that should be a part of the cost of juvenile detention. It's not something that should break the ability to, or stop the ability to have these in-person contact visits.
Thank you.
Yes.
I have a question.
Yes.
Well, I don't have a question more than a statement. I find your whole presentation a little bothering to me, only because I don't know if I trust the adults in the room to have the best guidelines for the children in the room and the parents. I know that sometimes we can be a little authoritative,
Okay.
and I don't know when you have a captured room of people, whether whatever they did, you know, whatever they're still people, they're still they may be young, but I have my spidey senses are telling me in some of these facilities, there's probably some strong arm stuff going on, and I just because I maybe I watch too much TV, but TV is based on reality, and I think I'm a little concerned about about the adults handling the children in the room and being a barrier to the family, not being able to have the communications, and
Yeah.
that is tied with behavior, because a lot of times if it's tied to behavior, sometimes your mama can just look at you. I mean, I don't know if I'm the only one that had a mama that could just look at you and you shut up. You know, it's a little authoritative on the part of the people that run the facility for me.
Okay.
I think that I'm having a problem with trusting them to bring the families together without being a burden and a barrier.
Okay. And I appreciate that comments those comments greatly. And I'm not talking about from TV experience, but I have a Google alert set up for juvenile delinquency and other juvenile topics around the nation. And bad things do happen in these facilities at times. And children are vulnerable when they are in this position of being in a facility. So I'm trying to make a positive step forward while also not trying to, I guess, attack our juvenile detention centers or anything like that.
Your spidey
Yeah.
senses are up, you need to follow. That's
Yeah.
all I'm saying. If the women instinct, I'm sure I'm gonna call them your spidey senses for men. If you feel that it is not right in any way, you need to figure out how to investigate. If it just right here,
Yeah.
you need to investigate, because our children are vulnerable. And a lot of times they've been in situations, they've been through things that a normal adult wouldn't even know how to live like that.
Yeah. And this will be an opportunity for the parents to check in, make sure kids are getting food, getting medication, that the adults are being appropriate with them.
I
Yeah.
think we find in the Children's Commission that sometimes the barrier are the people working.
Yeah.
And then they're good people, but then there may be one in a room that has a king or queen complex, as we want to call it. I just
Yeah.
need you to understand about the kids.
Yeah.
Yeah, and I would add, I think what the proposed legislation here does is set that floor for the quantity and the timelines for those visits and for those phone calls. But it also does kind of establish that beachhead and code where we can now talk about the quality and the supervision and the requirements of visits going into the future. So this gives that baseline, but I know what you're saying is a concern we're going to hear from a lot of places. So at least it will establish that place where we can come back and say, now let's talk about what the standards need to be for the visits.
I wanted it to be on the record.
Thank you. Rep. Devon.
I guess maybe it's a recommendation to our commission members is to go visit a facility. I don't know if you can make that happen or not, but I know our probate judge back in the day would always encourage legislators to come in and visit and take a tour. And some of you may not get out. I don't know. They might still have records of you, but I think most of you would. So I just encourage you as members just to take a tour and to do a site visit.
Are there plans to do a full fiscal analysis on this? Because I'm just going back to my years as being the budget analyst for Department of Correction. And I would think that there would certainly be a fiscal impact here to consider.
Well, I think we'll need to hear from the detention facilities. If they feel strongly that they're going to have to hire more staff in order to make this happen, I'm going to rely upon them to make that pitch. I think that the commission can still, make the recommendation for legislation, and then those types of issues be worked out as the legislation progresses.
Have you looked at, or I guess a suggestion just based on that would be looking at other states that have done, similar revisions that we would like to strive for and see if there was any economic cost there associated with it.
Yeah.
Joel, I may be jumping ahead, but I think the draft legislation looks really good. I did have just an overall bucket that I was curious about. There doesn't seem to be anything about kids who are in these facilities who have a DOC incarcerated parent. And I would be curious, as you present on the features, was that intentional not to include that? What do you think about including that? And what could that look like?
Well, we know that's going to be a barrier to in-person visits, but hopefully we can still have those audio visual. And so I think the legislation proposes that where there is a barrier to in-person visits, it encourages an audio visual visit instead. And so I don't see why that wouldn't. So are you saying that are you suggesting legislation to protect people in the DOC or to protect the children who have parents who are in the DOC?
Giving kids options to engage with their folks. It seems to me it would be necessary to call out in situations where a parent or trusted, however you worded this here, that you would include if that parent is incarcerated at a DOC facility, phone calls, video need to happen.
Okay.
I know that would be very difficult because there are costs there, but we know that adults can use their tablets to communicate. I just think it's important to call it out if that is intended to be an option. And I certainly think it should be an option because there'd be a lot of kids in facilities who also have adults who are in a DOC facility, sadly.
Yes.
Two points, Joel.
Yes.
First of all, we discussed this a bit in the executive committee meeting, and I pointed out at that point there wasn't a provision for no contact orders. So fairly often, there are no contact orders between parent and child or another adult and a child. And so I appreciate that the draft includes that now. That,
yes.
Prohibited contact is still prohibited. Second is really a question about the discussion in the group. I note that you have the DOC and also the Detention Association as part of the task force. And I noticed that the language in A2 indicates the facility can restrict unless the visitation would, or if the visitation would place the safety or security of the resident or detention facility staff at risk. But that doesn't include the safety of the visitors, including the residents' children. And I wonder if the detention facilities have expressed any concern about that, about their obligation to keep everyone safe in the room, not just the resident and the staff.
So the safety concern for the visiting individual.
Visiting individual, particularly, I think, the residents' own children. So I think facilities are extra concerned when they have, let's say, an infant child visiting the facility, making sure that everything is safe for that visit with that infant child.
Okay. I'll note that. And of course, we want everybody to be safe. And so we built that in attempting to try to make that clear. But if there's an additional concern, yes, we'll try to work on that.
A couple of comments I have about the draft. In 1B, you have authorized by the court. And so I worry a little bit about a formal court order being needed to authorize individuals in the process, right? Like the delay that might cause for visitation, waiting on that order. And is there a way for probation officers to authorize who can have contact so that it can happen more quickly?
Possibly. And I don't see why a probation officer couldn't file something with the court. And a lot of judges will have a connection with their probation officer that of trust, in that if the probation officer recommends it, that it'll be quickly approved.
Yeah, but I think I worry more about the detention facility than wanting a copy of that order, like.
Okay.
Process, right? Like for that order.
And if we can find a quicker way to approve those other individuals,
Yeah.
I'm definitely not opposed with that.
Would be helpful for them.
Yeah.
And then on 8A, and I think it probably pertains the same to 3A, where they have to document the reasons that were, the visits didn't happen, but there's no notification to the probation officer, no notification to the court to loop back around. It's just, they document.
Yeah.
So I'm assuming courts will want to know how often were visits happening? Did they get to have them? Did they not? And why not?
There is another provision in juvenile code that allows access to these documented records in the juvenile facility.
Okay.
But if a report out requirement is preferred, I think that could be built into the legislation.
It's just to the probation officer.
Yeah.
Joel, to piggyback, and I know you're making a note, but on that point, so looking at subsection 3, to the point of the determination of what happens if a person can't visit. And I can email this to you so you can share it with the committee, but the takeaways we had in addition to what was just said was we're concerned that if you look at the clause, basically anyone in A1 who can't attend in person for any reason, the detention facility shall, and it enumerates these things. It doesn't mention how frequently that determination needs to be made. So for example, what if a parent or an adult wants to visit, but maybe the facility has a staffing shortage. So for whatever reason, in that instance, at that time, they don't feel like they can have a safe visit on the facility end. But what if the parent wants to try again in the next week? So I think maybe like a visit by visit request determination, like some language that says this determination has to happen every time a request to visit occurs.
Is that a lot?
I'm sorry?
Is that a lot, don't you?
I don't know that it is a lot. I mean, what if you have an uncle that's coming from Missouri to visit and they can't get in because the facility says it's not safe because we have a staffing shortage? Okay, well, there's nothing wrong with the uncle. It's just the facility couldn't accomplish it. The uncle might not come back till months later. So it doesn't necessarily need to be a lot. If you have perhaps a family member, a parent who wants to come, but they're on the sex offender registry, like there's a reason why they cannot come in. Even if that adult kept trying to visit, once the facility says you can't come, it's not safe to have you here. If that person tries again, they could easily say, refer to our decision made on, our initial decision. So it doesn't have to be too burdensome, but just wanted to point that out, that you don't want a lasting determination. Like we already said, it wasn't safe for you to come. I think it should have to be every time. I made some notes. I'm trying to read my notes. Let's see, evaluate determination can't be based on. That's all. I mean, Joel, I'm thinking like you could add a D and say the facility shall revisit these determinations like at each request, and then somehow, yeah, I think that would be sufficient.
Yeah, and then so I would assume that it would require a family request to revisit the determination that a visit can't occur, or do you want it to just be every time that there's an attempt to make a contact, the facility has to revisit?
And be once they're based on facility capacity specifically.
Yeah, I mean, somehow you can't, you said it, Joel, we
Yeah.
can't let it be, it's not safe for people to come here because of staffing shortages. if the language just stays the way it is, I think this language could be in place and a facility could do that. We're permanently understaffed. We can't have people visit unsafe. And then it never gets revisited again. There's no trigger to make the facility keep coming back to make a determination of safety. So I'm just trying to build in some kind of trigger,
Yeah.
not trying to be burdensome, but something that makes them keep revisiting.
So this is, I appreciate all of this. This is the tough part of legislating something. Finding that right balance of being detailed and specific enough to account for foreseeable circumstances, but also recognizing that the code can only be so big and complicated before people are unable to understand and read it and follow it. But I appreciate all of these comments. So I didn't run through this slide talking about the components of the legislation, but I feel like I didn't need to because everybody read this legislation very closely. So just to briefly run through this. So this would be minimum standards for facilities. Facilities can always allow more visitation than what this requires. And we're seeing that some facilities are doing that right now. And I hope we don't discourage facilities from providing more when they see in code, we can provide less. I don't want to disincentivize anybody from allowing robust family visitation. And so we want it to be that behavior can't interfere with a minimum standard of contact with families. And I think that's in large part because of some of the concerns that Rep. Summer brought up, that kids are vulnerable. They need to be able to have an outside contact that's talking to them on a weekly basis. And that way, if something's going on that shouldn't be going on, they can report that out. Or they just need to have this communication because this is their life. That's their parents. And we need to make sure that that's who they're looking for guidance and trying to reestablish or improve that relationship.
Joel.
Yes.
Just one more comment. I would flag 7B
okay,
as something that could potentially get some pushback from other stakeholders in terms of, shall not monitor conversations unless exceptions occur or you have reasonable suspicion. I mean, number one, we could reach a point where every single call is monitored because there is a reasonable suspicion in the eyes of the facility. So who knows what the behavior would be. But if I'm just trying to look ahead and predict who's going to take issue with this or what would someone take issue with, I could see 7B being something, and that might be one to have either some prepared explanation of or data points on, especially when we're specifically calling out other individuals other than parents coming in. The facilities might suggest, look, there's real good reason why we record and monitor, not that we're just spying on everything, but we need records of in case we need to go back to a conversation we hear about after the fact because people in the facility are talking about what was shared over the phone, but there's no recording and it wasn't monitored because they didn't have reasonable suspicion ahead of time. Whereas you don't have anything to go back to after the fact. Just flagging that as something I could see some people pushing back on as we maybe get to some testimony and or debate on this proposed legislation.
Okay, I appreciate that. So with that, I feel like I don't need to go through the other components. Everybody's read this very closely. I appreciate that. And I greatly appreciate the committee's attention to this. And I need to ask Janae, is there anything that I should add? Of course.
There is. No, I just want to thank everybody. I think that this is just a moment in time where we're focusing on an issue that's important to children in detention. And I don't think that we're offering this as a solution to communication. I think the point that children, actually everybody is pretty vulnerable when they're in institutions. And it's important to have communication open so that we can protect that child and have an important advocate there to really help the institution itself understand the child's needs. And so we really appreciate your time today and looking at this. issue. We know it's complicated. We're not trying to do everything through legislation. I think this is a training issue too. I hope that we can continue. I hope we can get this legislation passed, and I hope we can start to train the detention centers on really what's happening around the country. Because more and more states and jurisdictions are saying family engagement is critical to rehabilitation and successful reentry and improved outcomes for children. So anyway, I just want to thank you for your time.
Yes, Chris.
Can I ask another question?
Yes, please.
And I know we
Please.
have, this is our county facilities, but we have a handful of state facilities as well. Would this not pertain to them as well?
So this, where this is proposed in the current draft would be for a juvenile detention facility, which are the county facilities ran by the courts. And it would not be something that would be imposed upon the Department of Correction. That said, I know that the Department of Correction is a partner with this committee, and I think that they would, I think in large part, they voluntarily comply with a lot of these concepts, and they do have good communication between children and families. Now, because we only have 3 state-run facilities across the state, in-person visits for a lot of families is a huge barrier because of the travel problem.
And I know it's a short session, right? So chairmen are going to have difficult. So I'm assuming this is going to go to judicial committees, and they'll get 40, 50 bills assigned to their committee, and they may be able to only hear 12. So you're author of the bill. So I mean, it would be great to get with the chairman of the committee to see if they would author this legislation,
And
because they might take it a little more personal.
we are hopeful that the weight of the commission's support for the concept helps greatly. So I think Director Krupp, did you have another question? Okay, I thought I saw
Chris
another
did,
one
I
over here.
believe.
Judge.
Oh, there we go.
Joel, Joel, I appreciate the initiative, appreciate the work on this. I would think it'd be beneficial for the commission to understand the scope of the capacity issues and the staffing issues at the detention centers. We don't know the scope. We've heard that detention centers are under stress. It's been mentioned here, availability of bed space. It's my understanding Marion County has a new facility which reduced capacity. And so before this, right or wrong, before this appears as another state mandate, I think we need to understand from the detention centers, what is their staffing? What are their staffing issues? This may or may not impact staffing, but I think stakeholders are going to want to know from this commission, what about capacity? What about staffing issues? So I would recommend that we were able to get some sort of report on the status.
Would you like us to consider that a motion?
So move.
All right. So we have a motion to receive additional information from Detention Association or detention facilities about how this may affect their staffing levels, or how their staffing levels may affect their ability to implement this legislation. Do we have a second?
Second.
Director Krupp? All right, any further discussion on that motion? All in favor of additional information on that point, say aye.
Aye.
Aye. Opposed, nay. So Joel, what would that timeline look like realistically when?
So I need to clarify, it's gonna, do you instruct the task force and the work groups under it to make that connection and try to determine what the capacity of the detention centers are?
That seems logical from my perspective, since you have momentum at this point. You've got folks at the table already on the task force to gather that information for the commission.
Okay, all right, well.
The Detention Center Association is on the task.
Okay.
Yeah.
Yes.
We have to process. working on this.
Yes, so we'll collaborate with the Juvenile Detention Association, possibly JDAI has some connections of, go ahead. Okay,
So our next meeting is October 15th, and then following that, December 10th.
Our next meeting is October 7th.
Okay, so the 15th potentially.
Maybe give a heads up to everybody prior to our meeting. To
Okay.
kind of, make connection on that and have something to report.
Okay. So Mark, would you flag this as a carryover agenda item, please?
Yeah, yeah, I can flag that as a carryover. I would know definitely by October, we've got legislation filing starting to get into busy season there. So I think that'd be a good goal to get no later than that, to get that additional information on any fiscal impact. So we can have that.
All right, before I say we're done with this item, I'd like to know, is there any other information that this group would like to receive at the October meeting? Or does this cover the concerns? All right,
Thank you.
thank
Thank
you.
you all for your time.
All right, moving on to our next agenda item, that will be the Best Youth Initiative recommendation. So Mark, would you like to take the lead on that?
Sure, and it looks like I have a couple items in a row, so fair warning, I have a new cat in the house and my childhood allergies have returned, so if my throat goes out, somebody's gonna have to cover for me on that. But yeah, we have a couple of pretty, hopefully straightforward items there. I appreciate all the discussion on our last one, though. It looks like we're really circling around some great work that's gonna be happening there. So the Best Youth Initiative, I've talked about this a few times, so we do have new folks in the group, so this is that initiative through the Forum for Youth Investment, where we're one of 5 states that were chosen to work on a specific topic area that's informed specifically by state policy leaders and youth with lived experience. So we've had a couple of meetings in DC with that group. We've done a lot of work around strategic planning and principal goals that'll be coming out of that. So I'm going to cover a few of those today in the context of a general position statement on chronic absenteeism. So I'll be requesting a vote when we get through that portion of it to adopt a position statement. And we haven't had one of those in a while. So just for reference, that is really just that North Star. So when somebody talks to the commission about what are you doing on chronic absenteeism, we have something to point them towards, saying, here's how we go towards addressing chronic absenteeism through our work. So we have that focal point that we can then build recommendations off of and grow some more things off of that. So it's really just that starting point. So a few basic items. Again, I don't think this is new to many of us, but really noting the complexity and root causes behind chronic absenteeism. There's been a lot of work on that. We've had 2 bills through Senator Donato trying to address that and look at all the different elements and how challenging it is and how there's such a great need to get our students engaging and active in school, regardless of what school looks like for them, in order to get that foundation really established. And chronic absenteeism, which is, we'll note we get some confusion on the definition here too. Chronic absenteeism is not the same thing as truancy. It's not the same thing as being an absent student. We've got a few different definitions in code of what that looks like. Chronic absenteeism just means, for whatever reason, 10% or more of the time, you're not able to attend school. Okay. And that isn't looking at that number through a punitive lens or a choice lens that the student just didn't come or the parents just didn't get them there. So that can be medical issues, mental health issues, being unhoused, all kinds of other things that fit into that. But we know we've got to look at all those variables because we also know when those catch up enough, it leads to a disengagement from the school process altogether. And that has serious downstream consequences, of course. We have in Indiana actually done fairly well post-pandemic on our chronic absenteeism numbers. We are ahead of the vast majority of states, which is really cool to see. We're still well above, though, those pre-pandemic numbers. So we tend to talk about the pandemic as almost kind of a trigger point where when we took away the requirement to come in person to school, there was a dissociation that happened there. Whether that was the fault of the pandemic itself or just an indicator of maybe we weren't as well engaged as we thought we were with some youth and parents, or maybe a little bit of both. That's really where we've been digging in and saying, we know we need to do better at getting them back. So again, just some of the basics on that. We also know that there's a big impact on reading. And I've talked with several of our DOE folks on this too, that the less you're there, the more your reading level tends to go down. And also the more your reading level goes down, the more by 7th, 8th, 9th grade, when you get into more complex reading, the more likely you are to disengage from school because you're not able to keep up with your peers. So it really just keeps feeding that mechanism into itself. So some really dangerous stuff, even with those young ages when we don't do that right. And I know our science of reading stuff, we've had some really good outcomes in the early months on that. And that's awesome to see. And I think that is going to help put a dent in some of these numbers. So that'll be just another thing that we lean into a little bit. And looking at some of the historical reasons for absenteeism, I think in the past, we really looked at just general academic struggles, housing issues, food issues, bullying, care for family members, other at-home responsibilities. But we're also now seeing a lot more, whether it's more prevalence or more just reporting, as we've gotten better dialogue on mental health and some of those concerns with that, feeling unsafe or insecure at school, anxiety issues. We're getting a lot more of those broader things that make it difficult for students to engage in a meaningful way. So we're digging into that and saying, like, again, so many of these causes aren't the ones that necessarily occur solely in the school setting. So we need to look at addressing things in a little bit different way and refocus our lens to do that appropriately. So what we have up front of you is a very broad statement on chronic absenteeism. That would be the proposed statement, again, with these other slides that I've got in here as well going alongside it. But just noting, due to the importance of consistent engagement and attendance, chronic absenteeism must be recognized as a complex issue that requires a coordinated, multi-systemic, multi-agency response to reduce its prevalence and address its underlying causes. So all this does is really take it out and say, it's about us all working together, and it's not about finding one system that is to blame for what's happening there, because we know it's so much broader. We don't have a system represented here that doesn't have a piece of the discussion on chronic absenteeism. We have some that are more of the data holders of it, because they're the ones that get to say, well, is the kid here or not here? But we have all the factors that drive well before that day where they're not there, right? So this is just taking that and saying, let's level set and say, we're all in this one together, right? So a few items that we're establishing specifically under that through our work with that Best Youth Initiative. So we can say, well, how are we doing that, right? This is the next part, is the how. So we've got our why, we've got the statement. The how, we have 4 very broad goal areas, and you'll note that these are not assigned to a specific entity or agency because, again, we're looking at that broader level of engagement on these issues. So one of those is establishing a statewide chronic absenteeism goal. Now, we've actually got some good progress with that with several of our stakeholders, including DOE. They're trying to find and saying, yeah, what is that? What are we aiming for, right? As we're aiming to do better, well, what does better mean? What do we want to get towards? So hopefully we'll have some announcements on that in the coming months. I know that's still something that's being sorted out of what that will be. But again, we need to have an aim before we can have strategy. So developing that. Looking at model attendance meeting practices. So those meetings that might happen at the schools might happen with an outside provider, might happen with prosecuting attorneys. Again, I know DOE is digging into some of this as well. We're collecting information from several different national initiatives that have shown great outcomes. So whoever is engaging on improving attendance, whatever system that is, has at least the guidebook of saying, here's the starting points. Here's how you need to approach that. Here's how you make sure it's engaging instead of something that's so punitive that, if anybody here's ever been part of a punitive meeting, you usually say whatever you gotta do to get that meeting over with. You're not necessarily engaging with the meeting and making permanent change. You just want to clear that hurdle. And that's not what we want. We want a better relationship at the end. So we'll be developing some of those, again, looking at early next year for that. Attendance resource guidebook, which we've already found is probably going to be a collection of several different guidebooks. We've got DOE's got some in code that they're required to put together there. We've got through our Youth Justice Oversight Committee some work we're doing on diversion programming, which would be kind of that other side of it, and saying if you're getting close to justice system involvement, how do we pull that back into something that's happening in more of a community and school-based level. And then engaging youth and families. This goes strictly under House Enrolled Act 1098 from last year under the CISC, and saying as we're looking at all of our family and youth engagement statewide planning, that we make sure that engagement with schools is a part of that planning. So we're not treating that as something that's off on its own, because We know in an ideal world, that's the one consistent place for families and youth to be engaged in their communities. Even if we're not catching them other places, that's the place. So if we do well there, we build relationships where they're then able to reach out better and get the supports they need ahead of time in other ways, right? So those are kind of the four broad areas. They are written with some specific timelines attached to them. But again, the responsible party of that is this is work that the CISC is going to be doing under its Best Youth Initiative with the goal of reaching those benchmarks at some level. Also, none of these will be ones we get to that time and we say, well, that's done. We're not going to be like, okay, well, in June of 2026, we've got a plan to engage youth and families. Cool. Well, that ought to take care of itself now. Obviously, that work's going to continue in the long term. So all of these will be evolving products, but looking that we'll have something that we can point to in each of these 4 lines by that time. So, so really, that's what I have on that one. So we're looking at an endorsement of that language specifically, the proposed position statement, and then those deliverables that would fall under that. Any questions? You still have some left.
Not that much, do I? Can you go back to one of the slides? I had the bullet points. There it is.
Mhm.
When you mention accountability systems, can you elaborate on what you mean by that is my first question. My second question is under the second and third bullet point, do you think there's space to mention or use the word incentives? I know that some school corps around the country are looking at like incentives just to encourage kids to engage with school and participate. And I feel like calling that out, that incentives are part of either bullet point 2 or 3 could be helpful. So my first question, what do you mean by accountability? And then second question, can we use the word incentive somewhere in the bullet point?
Yeah. And the accountability systems part on that, and definitely as we get this will all be into a printed one sheet if we endorse there. That's really looking and saying, are we matching against the code created specifically in 482 and 282 that says these are the goals that more looking at the data systems and everything else the DOE has to implement under, that whatever goal we create is a match for that. So we don't end up with yet another thing that doesn't connect with the rest of the discussion. So that's one we can definitely flesh out more. Yeah, and I think your point's absolutely right as we're looking at, and there's a lot of cool evolving things going on with some of the incentive-based pieces. So I've been following some of that research too, and we've had some good pilots actually in the Indianapolis area and elsewhere in the state. I think that's something that we can really look at integrating into, whether that's under the resources part or some of the model practices, that we make sure that that's indicated in there. You know, and I'd be fine adding that to say to be inclusive of any incentive-based systems.
Any other questions or comments? If not, do we have a motion to approve the proposed position statement on chronic absenteeism? Okay, Senator Donato, thank you. Do we have a second?
Second.
Thank you, Representative Bond. Motion and second. Any further discussion? All in favor say aye. Aye. Opposed, nay. All right. Thank you, Mark. And you're up again.
I haven't even get a chance to get down yet. All right, so next up, we're looking at building out a supportive relationship regarding the Child Welfare Task Force that was created this last year under House Enrolled Act 1273. So I'm going to give you a little bit of background on that, and then what we're saying when we mean a supportive relationship. So what goes under that? So we're getting a nice sampling of different types of recommendations today, aren't we? So, so supportive relationship is what we're looking at here today, but first going through the task force. So House Enrolled Act 1273 created a child welfare task force that is set to study some specific areas. You'll see most of these are no stranger to the commission, but this is also one that was built around a 2-year, 2 reporting cycle term. So it is a time limited and specific task force. The basics is looking at the child safety standards pertaining to qualifying as a child in need of services, the need for various types of child welfare services in Indiana, the need for child welfare service providers in different geographic regions throughout Indiana, methods to assess the quality of child welfare services offered, and the reasonableness of time for a child in need of services to reach permanency. So these are quite broad. I will note that these are taken directly out of what passed in the law. So this is what has already been vetted through the legislative process and come out on the other side. So it was built to come up with a set of annual reports that would go to the Interim Committee on Child Services. And that's a standing one. I sit on that. And we have others in the room that are on that one as well, that collects that. So this is really gathering that information to inform a report towards them. It does have a membership roster also in code. So you've got a few of the usual ones in here. So 5 members of the Senate, 5 members of the House. I believe that's a 3-2 Republican and Democrat split on each one of those. A judge appointed by the Chief Justice, representative of a child placing agency, in-home provider or provider of family preservation services, representative of a child caring institution or private secure facility, a group home provider, older youth services provider, provider that runs a child welfare prevention program. What we always love to see, a member who is at least 18 years of age and who has had lived experience in the child welfare system. See, it's catching on. Okay? We actually saw this in several bills this year, by the way, which is really cool that we start seeing. That's one of the automatic on the list ads. So I'm always going to pause and point those out because that's really good to start seeing. Juvenile probation officer, the DCS director, deputy director from DCS, and chief of staff or director of the Division of Mental Health and Addiction. So again, these are what's in code listed that would be a part of that task force. So what we're really looking at is the CISC offering a supportive relationship in there. With a lot of these committees and task forces that get created in their interim, we look at them from a few different ways. Sometimes there's a limited staffing and support that can be done through the General Assembly for them. And sometimes they're a good fit for work that's actively happening within the CISC already. This one really kind of checks both of those boxes. So we would like to be able to say, let's be collaborating as we go through this process to make sure that we're not creating something that's fragmented away from the discussion and has the support to pull together the right resources. Even on that list of members, you can see, well, there's a lot of duplication there through our CISC membership for sure. So this is what we call a supportive relationship. We've had this in the past with our Child Welfare Reform Task Force. We do a lot of this work still through the Youth Justice Oversight Committee, which has now been folded more directly into the CISC. But for these specific and time-limited ones, we say, okay, what supports can we offer uniquely to help in your position on that? So we're looking at general in-kind supports that we can offer there. So that will be staff support, such as assistance organizing, communicating to members, looking at specific member needs related to the task force, helping with onboarding and understanding of some of the materials. We have some that this will be old hat to them and some that this might be newer material. So anything we can do to aid in that transition and forming the task force, getting it together. Meeting planning assistance and scheduling and managing logistics of the online and in-person meetings. And then use of the CISC website as that portal where the information can be housed and pointed to for members, for stakeholders, and for the public to be able to access and view those as they go through. We have already had a discussion with the legislator that wrote the bill, Representative Devon, that we will be able to have the physical meetings happen at the State House and be live streamed through their capacities there. So it doesn't add any undue burdens for us for any of the costs or elements of that, and allows for that reasonable separation to say this is a supportive relationship. It's not a direct task force of the CISC. Those usually come through our strategic planning process. So just saying we're going to do the things we can to make sure that we're no strangers to the work going on at task force. We're supporting it with the resources that we do have available there. And of course, making sure it happens and those reports get generated and good work can happen from that. So that's really what we're looking at regarding that. And I'm open to any questions on that one.
Absent any questions, do we have a motion to approve the request for a supportive relationship with the task force? Thank you. Do we have a second? Okay, we have a motion and a second. Any further discussion? All in favor say aye. Aye. Opposed, nay. All right, thank you, Mark.
All right. So, and the first one of those will be scheduled for immediately following our October commission meeting. Not immediately, we'll allow a lunch break in there, but going over to the State House, I think we're looking at 1 o'clock. So taking a break and then resetting over to the State House for those. And again, like anything else, there will be capacity for guests to be available at that. So more information coming as we get all the logistics planned out.
And finally, Mark, your executive director report.
Right, we're almost there, almost there. So a couple of just brief items that I want to make sure that we touch on before we're done for today. Strategic planning, we've started the process. We've actually been talking a lot to our task force and our task force chairs. So they've developed some early work towards objectives that might go into that. And I know in strategic planning, sometimes we've been maybe a little bit too much top down. We create them and then say, well, task forces figure out how you're going to implement those. We're trying to reverse that a little bit and saying, let's make sure we're having a mutual discussion on that. So we've got some good starting points on that as well. We are looking at a full day strategic planning session. Right now, you should have gotten a poll. And if you haven't answered that yet, please do. Otherwise, just tell Blaine on your way out. We're down to September 23 or 24 for where we're going to have that full day session. We did start with our folks that have additional commitments that they're not paid to be in that room for that day to make sure that they're available for that. So that's how we got down to those 2 days. So hopefully you can join us on that. We'll also have our task force chairs and other select members that come to that to make sure we have a very informed discussion. It's going to be largely focused on taking some of the objectives and saying, how do we make these truly measurable and truly ones that we can say the Children's Commission's work attained this goal? So that's something we've had as a roadblock to retention of members of some of our task force in the past. They're saying, we think we've done good work, but our goal is so broad, all we can do is say, we think we've done enough on that one. Let's go to another one. So we want to do a little bit better in that space. We do have our partners at the Forum for Youth Investment have offered to lead the strategic planning for us and at no cost other than us covering their travel, which in these cost prohibitive times, we appreciate. They do, historically, their work outside of the Best Youth Initiative has been on positive youth development frameworks. So really looking at how do we sprinkle in a lot of that family and youth engagement and the lived experience voices throughout all the work we're doing, but also how do we make sure we have goals that can really measure that we're doing the things that we're aiming to do. So they've been very generous to offer that support. And of course, we appreciate that. So again, the 23rd or 24th of September will be that. If you are unable to make those days completely, we have lots of other ways we're going to be making sure we poll you on that. And the next 2 commission meetings will have components on that. So since that meeting's happening in September, we'll have an initial report out draft in October. Hopefully by December, we're looking at here's a final of that strategic plan. So we have multiple points of discussion. They're still going to happen since then. And we're polling all of our outside stakeholders that we work with so regularly to make sure they get input on the goals and the objectives, that they're right on track with that. So a lot of good work happening there. So any questions on the strategic planning process? Okay. Everybody just wants me to get to the last point, right? So our annual report, we don't have it ready for viewing today. So they are going through all the checks and balances to make sure it's got all the accessibility pieces and everything else as we speak. So that will be sent out to all of you electronically. By code, it's something that we just vet through you all. So we ask you to look at that. It is due by September 1st. That's the statutory deadline we have for that. So we will get that out to everybody as soon as possible. If you have thoughts, feedback, edits, if you just think a colon should be a semicolon instead or any of that good stuff. No Oxford comma people, just don't even look at it. Because you'll have to deal with all my run-on sentences in the intro. Just get us that feedback so we can make those changes and get that out and published. As usual, we've gone away from making that just a list of here's our meetings and when they happened, and much more about here's the ongoing work we're doing, here's what's happened since last year, here's what we're leaning into next year, and really making sure the product that each of you as members of the commission can hand to somebody and say, if you want to know what the commission does and how it does it, here's some good information for you. We want to make sure you have that in your hands. So again, that should be ready in the next couple of days, and we'll send out to you electronically as soon as we have that. And that, believe it or not, is the last item on my list.
Any questions for Mark? All right, our last agenda item is commission member announcements. So why don't we start at the opposite end of the table this time? Representative Devon, anything you'd like to share today?
Just hoping to get the Cubs in the playoffs this year.
I don't have anything.
I don't have anything at all as well, but I'm excited to be here with you all.
I also don't have anything, but happy to be here.
Nothing for me.
Okay. Mark?
I'm good.
Right.
Good.
No, thank you.
I'm not gonna break the mold here. Pass it over.
Quiet group today. All right, 25 extra minutes in your day. So thank you all for a very productive discussion today. Have an excellent rest of your day. We are adjourned.